I believe. I'm not sure.
I'll be back in a minute. I'm dealing with YouTube right now.
I got a note that says meeting is being live streamed.
Right.
Yep.
That Hammond
Okay.
North said,
I will go ahead. I'll go ahead and let everybody in.
Randy, if you make me co-host, I can help with this.
I still don't
Okay.
think John's here because that Hammond North turned into Bruce Fairbanks.
Oh, you're right.
Okay, Jan, I made you co-host,
Okay.
Yes, John.
so you can kind of watch people over there.
Yeah.
Okay.
And
Where's
you
John?
unmute John. He's dialing in from his phone.
I just asked him to.
Okay, try to unmute yourself.
Must not be going through. There we go.
There we go.
John?
Still
We
can't hear you, John.
computer. We can't hear you on the computer. You want to just dial in from your phone, dial the number?
Let's go ahead and start the meeting.
All right, everybody, this is August the 26th at 6:07 p.m. This is the regular monthly meeting of the Hammond North Condominium Association. The first thing to start off with, we're having some problems with John connecting in right now, so we'll take attendance. Randy,
Here.
Ann,
Here.
Tracy,
Here.
Chris,
Here.
Joe.
Here.
All right, we have a quorum and we're trying to hook John in right now. So,
Here, I'm gonna admit him again.
as has been the practice lately, the chat feature has been disabled and owner questions are allowed. And we are going to limit questions to 2 questions per person on the matter at hand because we have some time constraints tonight for some of the board members. So first order of business is approval of the minutes. Randy?
I move that we approve the minutes of the meeting of August 5th. Those were sent out a couple of days ago.
I second.
Any discussion? Gil?
Randy, there's one point on here, and I apologize for not getting back to you sooner. It says the association, well, that's not it. Wait a minute, is that it? Will make no loss assessment from Burnham. What does that mean?
That's what somebody said in the meeting. I don't know what
Anybody
that
know
means.
what that means?
Gil, can you repeat it?
Says the association will make no loss assessment from Burnham.
Oh, that's part of the settlement.
Language.
What is the
Gi-
loss assessment is my question.
Yeah, but Gil, what part of the minutes is that? What's the subject
It's
before
under
that?
the legal part, Burnham settlement signed in the minutes. It's the 3rd bullet point.
It could be that the board is not going to do any additional loss assessment against Pat Burnham.
Right, for that unit, that
All right,
the
I'm done.
108.
We can not hold this up and dig deeper into that if we want to later.
Clarify it.
Okay.
All right, any further discussion? Okay, all those in favor of approving the minutes? Unanimous. Okay. John, do you want to take over now?
Not really, because I was relying on my phone to read the if you announce, Tim, if you announce what the item is, I'll take over from that. But the problem is I'm limited being able to see owners, even all the board members.
Okay,
But so,
All right. I'll do it, and if I need you, I'll let you know.
okay, thanks.
Next on the agenda is the building manager's report. Greg?
Well, thanks, Tim, and good evening, everyone. And knowing that the agenda is full tonight, I'll make this as quick as possible. But there's some recent repairs that we thought would be prudent to update everyone on. That was a result from the last two storms that we've had and some other ongoing repairs. Starting with the elevator update, we were able to repair the two circuit boards that were affected by the last lightning strike from the last storm. And as of yesterday, all three elevators are back in full operation. We still have 4 cameras that are down. There was a DVR that was replaced, and a couple other cameras that were wiring to the cameras were repaired. There's still 4 others that we're working on, and the service request is still in for that to be scheduled. FOB fob update. We deactivated all the fobs other than those that were designated by the board to remain active. That was completed as of yesterday. The cooling tower and the chiller are all in full operation now. We did have to rerun all the wiring from the cooling tower to the boiler room and to the controllers. We had to replace 2 controllers and run all that wiring, and altogether, those repairs were about $26,000. But as of today, the cooling system is in full operation. The unit that was installed in the the lower level north side, that was installed for the winter to help maintain some heat in that area, that had developed a leak here recently. We have a temporary cap on it and a service request for the contractor to make a more permanent fix is in place. We did have the lightning rods and cabling on the roof and other areas of the building inspected today. I don't have all the proposals or the recommendations yet. I'll share that upon receipt. The air handler that's located in the laundry area ceiling that supplies air to the north side of the building. I believe that has been fully repaired, and that was about a $4,000 expense. But as of today, we are not experiencing any additional leaking or any other concerns about cooling the air going through that air handler unit. And I believe, Tim, that concludes the manager's report unless there's any immediate questions from the board.
Okay, Randy?
Yeah, and the fob situation. Did we ever, this is not necessarily for you, Greg, but did we ever decide exactly what we're going to do if people want to drop their payments, HOA payments off? If the guard is not at the front desk?
I don't think we ever really decided that. However, I think owners mentioned that there's a security question of putting something outside the locked doors. So we could talk about it, but I think I recommend that we only have something inside the locked doors for dropping off checks.
Okay. Tracy, you were next.
Greg, do we have the invoice for the fob work and the chillers yet, just to get an estimate of what that's going to be?
I did the fob work. It was just a matter of programming.
Okay.
So there's no additional cost on the fobs at this time. And again, those that were designated by the board, i.e. the board members, the current staff, and front desk, those fobs remain active.
Okay.
And if
And what-
need be, we can reactivate, another fob upon request by the board. But again, all the previous ones have been deactivated.
And do we
And
know
I'm
the chiller
sorry,
costs?
you asked me about the other question. I'm sorry, what was the other?
The chiller costs. You talked about the chillers.
Yes, I could definitely send that to you.
Okay.
Gil?
Chris he had his hands up before me, and I think go ahead, Chris.
Okay, regarding entry to the building, it was suggested that anyone who is going to be coming to the building should first call and let either the guard or Mickey know about what time you're going to arrive. And that might be the best way to ensure that someone is going to be available to let you in. I'm
And
done.
that's what I remember as well. That's what I was going to say.
Okay. Randy?
Yeah, we have 72 people, now it's 73 people in this meeting. Should we send a one call to that effect then?
Yes.
That people should call ahead if they intend to try to come in the building?
Yes.
Yeah.
Can you do that, Greg?
I can.
Thank you.
Any other? Gil?
So Greg, as far as the lightning protection company that was in there today, can you get them to give you a date when they're going to provide that to you?
Yeah, I should be able to, Gil. He had to go back and look at the blueprints because they were actually performed some service in the building back sometime around 2018, 2019. And that's how I was able to locate them. So he thought he had some drawings because they did some of the initial install there, but he had some questions and he couldn't fully determine where the ground faults and where the grounding was in the outside of the building. So he wanted to revisit that, but I will definitely ask him to see if he can't commit to a date.
On that same but different on the cameras, we've been going over this for way too long. We need them to give us a commitment when they're going to be here, or we need to start looking for somebody else.
Understood. Will do. It's just that they did the install, they're familiar with it, but we can certainly
I get it.
Yeah.
I agree with you.
We'll
But
look elsewhere if we can't get a commitment.
It's been weeks.
We just need to jack them up if they're having problems getting material or something. We need to know what the problem is.
They're telling us that they have a problem scheduling two people because they need two people to be able to, I guess, check both ends of the cabling.
All right. Any further discussion on the building report? Next item on the agenda is the treasurer's report, Tracy.
Thank you. First, glad to be back. So thanks for people for holding down the fort. So for the treasury report for the month of July, the operating account ended July in $160,115.29. The reserve account ended in July was $15,175,053.37. Total current assets equals $16,205,766.36. And our prepays in July is $58,290.19. For the delinquent report, the number of owners delinquent is 74. And that total is $760,145.82. I believe last month or the month before the last board meeting, I reported approximately 55 owners that were delinquent. And I stated that because there were some owners who were either 1 month or less in arrears. So going forward, we're just going to report the total of people who are on, or owners who are on the delinquency report, regardless of the minimal amounts. So that comes to 74 delinquent owners and totaling $760,145.82. Also, I believe I was on the agenda for the finance committee. Due to me being out, we have not met, but we do have a meeting scheduled for this coming Monday.
Okay. Any questions, Gil?
So on the operating account,
Mhm.
we have cash special. What is that?
I would have to pull the report you're looking at. I'm just reading the treasury report. I'll go back and look at it. Yeah.
It impacts what our operating account is. That's why I'm asking that.
Hold on, let me go grab it.
This is on the balance sheet report.
I'm getting there. Give me 1 second. All right, so you're looking at cash operations and total funding?
That's
Is that what
correct.
you're looking at, the $21,358?
Correct.
Where it says cash special? I'll dig into that. I believe that is a portion of the actual operating interest cash, but I'll dig into it and send you a note back.
So where is that? Oh, you don't know where that's sitting then. You don't, if it was what you think it is, where would that money be?
Do you mean what bank account?
I guess. I mean,
What-
why is it broken out from operating account and Northside Bank?
It's broken down by GL account and where the cash sits. So we have many banking accounts, and I can get you what that one is.
But I guess I'm asking, why would we have those extra accounts? Why do we need an account that says Northside Bank versus the operating account?
It's just the labeling.
It's not just labeled.
So account the GL account 110425 that says cash Northside Bank is cash sitting in that account. We have multiple accounts that holds funding for Hammond North. And I can get you a list
For
of
operations,
those.
we just
Greg,
have
I'll get
three.
with you. Oh, I'm sorry, go ahead, Gil.
For operations, we just have three.
I'll get you the list of the accounts.
And then on the capital reserve, in two places, it has a 15,282,000. And then on the treasurer's report, there's a different number, 15,175, which is a difference of $107,000.
Repeat that on the capital reserve report. What number are you
On the
saying?
capital reserve report and on the total liabilities and owner's equity, they both say $15,282,392. But the treasurer's report says it's $15,175,053, which is a difference of $107,339.
So I'm not seeing that number. Let's take this offline and work through it, and then we can send a response back out.
It's on the balance sheet. It's from receivables, Tracy.
All the way at the bottom.
No, it's in the top part of the balance sheet. The
Oh, I thought you
107
said in the reserves.
The 107 is receivables from operating, so it's deducted from that amount.
Oh, I thought he said reserves. Yes, you're talking about under current assets, Gil. Is that what you're referring to?
Just telling you where I'm seeing numbers and trying to understand how they all work and where they belong. So Greg, you says it's receivables?
Yes,
And I would see that where?
Under total current account assets. So it is the first page.
Of the balance sheet?
Yes.
So, and not to hold this up. Let's take this offline, and Gil, we can walk through all the line items on the balance sheet and the reserve account separately and send something out, because there's a lot of numbers on here, and without having these things pulled up, I can't explain what numbers you're seeing and what your questions are.
Greg, I do see that on here. I thank you. So I also had a question about the prepaids, and we can talk about that later as well, because I'd like to understand how that's being handled.
We can do that.
So what I saw here was in operating, we had an increase of almost 31,000. In reserve, we had a reduction of 368,000. And in total assets, we had a reduction of 700 and almost $17,000. Does that sound correct to Greg and Tracy?
Yes, that was your
Yeah.
insurance. That was your insurance payments.
Insurance premium. Yeah.
Yeah, we had to pay those because you went active July 1.
So
there
that
wasn't-
would be, go ahead.
I'm sorry, there wasn't enough in your operating cash to pay those invoices to activate that insurance.
Okay, so that would that would take care of what I've just said in reserve, but that still leaves a difference between the total assets and the reserve of almost double that number. So you might want to take a look at that and get back to us.
Yeah. Okay. Let's
And I
take it
think there-
offline.
And we've also got in the, I don't know, the budget report. I guess that's the income statement. Somehow we've got the insurance payment in that too. Should that be in that? Because that just came out of reserves.
So if you remember the email I sent out, I talked about the entry that needs to happen for the insurance out of reserve. That's what that email was for, that I sent out to the board.
So are you telling me we transferred the money from the reserve into the operations account so we could pay it?
Not yet, but we're going to.
No,
We've
we're not.
we've already paid it out of reserve. Now we're
Right.
going to move it into operating because that's where you budgeted it. And that'll be reflected in August.
We didn't budget for insurance in the budget.
You did.
Did not.
So it's not in the operating expense budget. It is a debit or credit to the reserve account. And in the email I sent out 2 days ago, and to Greg, it mentions that this number, the $610,000 that was put in the budget, is not the association and the owners funding it. It is to come out of the reserve account. So there needs to be an entry that's going to be made in August to correct that. Greg and I have been emailing back and forth to get that corrected.
It's more to adjust it because
Right.
you have in your budget on 681,400 line. You have that budgeted at 610 year to date, right? Or 612 year to date, but for the month it was budgeted at 610,000. But we couldn't put it in operating because there wasn't enough monies in July to do that. So we have to transfer that from reserves to operating so we could pay down that. And that will reflect a shortfall in your overall reserves. In
Right.
August.
This is an allocation entry that needs to happen
Yes.
this
Yeah.
month. Yeah.
Yeah. It was anticipated, you budgeted it, but we couldn't put it in that line item because we didn't have the cash in operating to do that in order to process these invoices in a timely manner.
And then aren't we still waiting for another insurance bill, Gil? I think I saw an email while I was out about adding to what we currently have.
Yes.
Yes, and Greg has already paid that. Correct?
Yes, the check was cut Tuesday. It's 42,000 and some change.
Okay, so it's not in this, it's going to be in the next one, is what I meant. I didn't see it here.
Yes, yes.
Okay.
Come August, in the August financials, you'll see all the insurance payments to date. It'll be reflected in your August.
Okay. Thank you.
Pleasure.
Chris,
Yeah, I would suggest that the three of you get together in person and go through this so that everybody ends up with the answers that they want, and it'll be worth the time to do it in person. It is a difficult thing to do it over the phone or by Zoom. You all need to have information in front of you and discuss it in person. I'm done.
I would
Thanks,
welcome
Chris. I
that.
agree. I agree.
we unmute John Webb.
Yeah, so just a clarification, Tracy, I had it up. And I think the other account, and Greg, keep me honest here because you have other and reserves and other there. My understanding is when I was on the finance committee before, you said that was held at town so you could pay things separately. And then what was in the bank was in the bank. And then the multiple banks is in the reserves under, I forgot what it is, it starts with I, whatever, that's your multiple banks.
I see. Yes,
But
sir.
that's my understanding, Greg, and maybe you could just clarify that, go back. And then I think the other thing is, as far as the account, Greg, you're saying budgeted and some people are saying reserves. I think we're just getting our terminology mixed up because the way I understand it is, and Greg, keep me honest here, you have certain line item accounts with how you budget things at town, and it has to go through that line item. You have to transfer it. Now, the budget that Tracy prepared had it in reserves, but I think it's just an accounting issue. And that's my understanding of that as well with how you have it with town set up. But y'all can clarify that afterwards, but that's my understanding from the past. I hope that helps. May have confused things too.
That's correct, John, what you just said.
Thank you. Any other further discussion? Okay. Next item on the agenda is payment of invoices. John, do you want to handle?
Yeah, I'm back on. Apologies, I had to reboot the computer. Hopefully everybody will hear me. So the first bill is from Griffin, Fletcher and Hughes. They're the title firm that has worked with Finney for the petition that was filed last July. They did a refresh in January, February. That's bill number 18613 for $9,900. I have to say that I think, Gil, that you mentioned something that you thought wasn't quite right in the bill, and it wasn't. And I think the bill basically was cut in half because they only did one refresh, not two. And they also had the wrong, incorrect number of units. So the bill now is $9,900. And I make a motion that we pay that.
I'll second that.
Any further discussion? Okay. All those in favor of paying this revised bill of $9,900? Unanimous.
The second bill is for clerk of courts, and I'm just going to postpone that one because I believe that was something that should be paid through the lawyers. So there's still a clarification. So I can't recommend us paying that yet. The next bill is from Collier Service, and this is the bill as reported in earlier board meetings of the work that Tim did in calculating the additional work that was done in the building since the first appraisal. And the appraisal went from roughly $9 million to $17.1 million. So that's for $3,000 to do that appraisal. And I make a motion that's invoice number CMH 260361 for $3,000.
I'll second it.
Didn't we already approve that?
We approved it, but we haven't paid the invoice. We approved we approved telling Colliers that they could do it.
For that amount of money, doesn't that count?
That just says the bill is going, that work is going to be done, but we don't actually pay anybody until we get an invoice, a bill, and then we make a motion to pay the invoice.
Right. Any further discussion? All those in favor of paying the Collier bill of $3,000? Unanimous. John?
The next one is some Porter bills. I'll do them individually. The Finney bills, excuse me. The first one is for Porter work, invoice number 42922 for $1,089. I make a motion to pay that.
I second.
Any discussion? Big deal?
John, is this one of the invoices that has?
No, it's not. That's invoice number N61 and 62. That'll
That's
look
right.
very, yeah. I'll
good.
call on you when we go to that.
Okay.
Okay, all those in favor of paying the Porter invoice of $1,089? Unanimous.
The second one is invoice number 42923. That's on work on the Pat Burnham case. That's for $1,577.50. And I make a motion to pay that.
Second.
Randy seconded. Any
Who did?
discussion? Any discussion? Tracy?
The last invoice we paid for Burnham after we finalized the agreement, I thought that would have been it. Is this additional work to actually file everything, or?
It has to be, there's still dialogue back and forth between the lawyers to make sure the whole deal was finalized. This covers a period from a month earlier. We're billed monthly. We have gotten the quitclaim deed for unit 108, as we mentioned earlier, and we are still has to be filed with the courts, and we still have to receive the money from the insurance company. So there'll still be some more work.
Okay, thank you. Sorry, I'm just catching up. Thanks.
Randy?
I missed, who seconded this?
I thought you did.
I think it was Chris, wasn't it?
Oh, Chris, I'm
Was it
sorry.
Chris? Okay.
I
Okay.
need to approve it then.
All those in favor of paying the Burnham bill? Unanimous. John?
So the next bill is 52961. It's for petition work. It's $9,727.50. It's ongoing work and motions, primarily back and forth communication with board members. But as Gil has mentioned, there is some minor fees. I don't know exact amount. I think it's around $150 of reading emails from an owner. And so that's what's in there.
I might add that have nothing to do with that particular litigation, or at least it's not part of partition. It was just a random email.
You're talking
The bill
about
doesn't specify that, but I think you may be right.
Chris?
Well, there's typically don't get to contact legal, and I think that part of the bill should just be passed through and assessed to the owner. My opinion.
Tracy?
Chris, I'm sorry, were you done?
Tracy?
Oh, okay. No, I was just gonna so we're being charged and billed for an owner reaching out to legal in some way, whether reaching out to them or whatever, because obviously they pay per hour and whatever work that they do. So is this something we need to discuss to say this shouldn't happen? Because again, to your point, Chris, we're being charged for that situation. Like
Randy. Randy,
Yeah. Um, okay. This involved Julie, our lawyer, who's been running the partition action. One of our owners emailed her. That owner happened to be one of the plaintiffs in the partition, of which we had like 110 of us or something like that were plaintiffs. She then is their lawyer. And so when she saw an email from this person who was one of her clients, she had to open it and see, what this was about. A lawyer cannot just ignore one of the people that she's representing. So that's how come the bill was, it arose. Apparently there were two different emails. Each one came in for 40,
$46.50.
50 cents. Yeah. And I think that we need to remind owners that even though if you are a plaintiff, you do have the right to contact a lawyer. We can't tell you you can't talk to your lawyer. But the problem is we're getting billed for that. And so this was, I understand there were two emails. I cannot figure it out from the invoice. It seems to be mentioned 3 times. Two of them were on July 2nd and one was on July 3rd. So if we're being billed for all three, that's $148.50. I don't believe we can send that bill to this particular person this owner that initiated that email, because we had not made any policy, made any plea to the owners, please don't do that. I would like to say that just off of my, if you feel that you have to reach out to one of the association lawyers, whether it's Isaac or Julie or even Chris Finney, contact the board first. Because, as John said, here we are, we're looking at $150 because somebody took it upon him or herself, to do this. The kicker is, it turns out it really didn't have anything to do with the partition. And so Julie didn't answer, which would have, had she answered, it would have cost 3 or 4 times this amount. These lawyers make huge amounts of money per hour. So even if she took 10 minutes to read the email, that's where this $46 charge comes from. So yeah, that would be that. But I think that we hadn't warned people, don't do that. So I just don't see it's right to pass this on to that particular owner.
Gil,
And my feeling is we have no ability to control owners. This can spread beyond one owner to multiple owners. We can't take responsibility for owners contacting an attorney. That's the attorney's issue. That's part of their working environment. It's up to them to decide if it's not a defendant or somebody that is part of a legal situation they're working on, that they're involved in, then they just need to respond to that person and say, if they want to respond, they don't have to, but if they want to respond, they say, we can't represent you on this case, and leave it at that. That's on them. We don't need to be taking that on. We don't need to be sending notice to people. We don't need to then bill people for what they incurred in costs. We're not the clearinghouse for them. We didn't ask for it. We can't control it. We shouldn't set precedent to start paying for that. This could get real ugly in a hurry. We just need to nip it in the bud right now. Finney is not going to push back on that. They're making way too much money off of us to be worried about that.
I think what you got to consider though, Gil, is what Randy said. The person who made the contact is a client. And they're
I understand.
part of the suit.
I understand, but that's what I said. Once they know that it's not actually a client, then it's on some other subject, just like any other situation. If you had an attorney and you were doing business with them, and then you contacted them and said, "Oh, I'd also like you to work on this," but they're already an attorney for that other side, they're just going to tell you, "I can't do it." Whether they charge you for that, I don't know, but they don't need to be charging us for that. It's not our responsibility.
Yeah, this is what I thought was a simple question originally. It's much more complicated. I think that the partition question is very real. Every owner who is a plaintiff in the partition case is a client of Finney. And so they're going to have to read an email if it's about partition. But if it's another case, then I don't think it's quite the same situation. I think we need a legal opinion on that, and maybe we need to set rules on it. But in this situation, after the fact, with us not having a rule, I don't think that should hold up this bill for this amount in this situation. If it's going to be another case, it's another story. And I think that actually Gil correctly pointed out, this is under the partition action. And all the board members got copied on this email, and those emails were not about the partition case. But what that means is that Julie, the one who got this and read it, was going to have to charge it to a different account, and it would be the general board account. So that could happen, but we're still going to end up paying it because there's a legal obligation if the lawyer gets an email to read it. If we want to set guidelines how these emails should be read and worked on, or charges for it, we could set them up with Finney. But after the fact, I think that's probably not advisable.
Chris.
The person who sent these emails was an ex-board member who knew not to contact legal. There has never been a time when individual owners have been allowed to contact legal and incur costs for that. And you guys know that. So the way to stop this from happening is pass through the charge to the owner. We're talking about it in public, and everyone will know they can't do that. I'm done.
Gil?
Jan, go. She was before me.
Let's just refer this to the legal committee to figure it out. It's my thought.
Okay. There
Can
you
we
go.
see can we allow Jim Sissel to weigh in?
Yeah, I mean, let's just finish with the board members. And I think that's a reasonable idea. In terms of this getting out of control, it's actually in control. We do have it on this bill. There may be another one. The individual we're talking about has not CC'd any Finney attorney for the last 4 weeks. Now, it may come up again, but I think it's not an out of control situation. And in particular, I think we got to move this along. I agree with Jan, legal committee, but the question is, do we pay this bill or not? And I made the motion. If it fails, it fails.
It has not been seconded, by the way. And I'll second it.
It's not our cost. It
Can we,
never was our cost. It's the attorney's cost of doing business. Do not pay for the attorney's cost of doing business.
Then
No
seconded.
business owner in his right mind would ever allow this to go through.
I think there's going to be a big difference of opinion on that, Gil.
Yeah.
Jim Sissel, please.
By
unmute.
whom?
No, we have Tracy if you want to get through the board.
Tracy.
Sorry, I know a lot of people have their hands up. So, in my opinion, I think we pay this bill for now. we have now talked about precedent that it should not happen again, or the bill will be a pass-through. Now, because plaintiffs are a part of this petition, the attorneys will have to open the email, read the correspondence in order to decipher if it's part of the petition or not. That takes their time. And it just so happens that this communication wasn't not about that. So when you say like it's on the business, it's on the attorneys, well, they have to still do their due diligence to decipher if this email is something that they should correspond with. So I think for now, we pay the bill and we move on, and going forward, this is not something we're going to pay for.
Gracie, they have to open every email they get. They're not going through and saying, is this email from somebody from Hammond North? If they get an email, they're opening it. That's their cost of doing business. It has nothing to do with us. We have no control of it. We should not be paying for it. And when I say, John, that this could get out of hand, I'm not talking about the one individual. I'm talking about the other 170 some owners who could start, if they have agreements, start doing this. We don't need to be having to invoice all those people if they decide to get angry with us. It shouldn't be charged. But again, I would like to hear what Jim Sissel has to say about it. He's the attorney.
Well, it's not Jim Sissel that's answering this, but this is Carolyn, who was a paralegal for 25 years. And I'm telling you right now, I don't very often agree with Chris Conti, but I absolutely agree with him, particularly since this person was a former board member. And I don't know which former board member it was, but I can tell you when I was on the board, they had their heel on the neck of every other board member and would not allow us to talk to attorneys. So whoever that board member is, send them the damn bill, especially since it didn't even involve the case. And then you need to go to the law firm and tell them they are not to bill us for opening an email that does not involve anything to do with this. And you need to send a one call around and tell everybody not to call, not to send emails. They need to send an email to the board, and the board needs to talk to the attorney's office. That's how it should be done. You should not be paying the bill. I agree with Gil and Conti.
Thank you, Carolyn.
You're welcome.
John Webb is unmuted.
Yeah, so if you look at past history, especially during the past board, the Porter suit actually, she reached out to the attorney. There was not a precedent, nor was she charged. And they did that because she was trying to not file a lawsuit, which it ended up being there. And the person that wrote this, from my understanding, was a former board member, and they were concerned about a conflict of interest that was on the board at the time with paying out the money and making financial decisions based on the reports. That's what it was about. And the board was not answering those questions when raised, is my understanding.
I'm okay with going with what Carolyn said. That makes sense to me. We'll go ahead and pay this one. We need to tell the attorneys no more.
Carolyn suggested that we pass through that portion to the owner.
We have a motion on the floor right now to pay the bill.
Let's
Any
vote.
further discussion on that motion? Okay. All those in favor of paying the bill as per the motion? Those opposed? 5-2, motion passes. I do say though that we make a published announcement that no more.
Yeah.
Anything else? If this comes up, no questions asked, it will be passed through. John, you have another invoice?
Yeah, there are a few more. There's one more Finney bill, 52962, General Corporation bill, $1,747.75. It has the same problem of the, I believe there's reading emails from this individual. I make a motion to pay it.
Second.
Tracy?
So is this invoice above and beyond the $150 that we just paid out of the other invoice? Is this an
It is.
addition?
And yes, each of the last bill that we just approved and this one has, I think, two mentions, as Randy said, July 2nd and July 1st of correspondence with this owner.
Do we
So
know?
the
Reading emails from this owner.
So the portion of the bill we just paid, we said was $150. What is the portion of this bill?
I'd have to look it up, but it's around the same order of magnitude. It's about $100, I think.
So we're talking 200 or $250 at this point.
If you add the two bills together, yes.
I guess my feeling is we need to be consistent. We passed one, we need to pass the other. Chris?
And my feeling on it is that we should not be charging 179 other owners for this transgression. We should be passing it through and charging the owner who generated the charges. I'm done.
We have a motion on the floor to pay the bill as is. All those in favor? All those opposed? Abstentions? 4-2-1.
Okay, the next bills are from a law firm, Allen, Stovall, Newman, and Ashton. This is a law firm that is handling the bankruptcy cases. And the first one is invoice number 41655, and it's for $88. I make a motion to pay it.
I second.
Any discussion? All
I
those
have
in
one quick question. How many bankruptcy cases are there?
Currently, I believe there are 3. The reason why I hesitate is there were 3 originally. Then one of them, I believe, were out of bankruptcy, and we were just notified yesterday that there's a 3rd bankruptcy. So I believe there are 3.
Thank you.
All those in favor of paying this invoice for $88? Unanimous. One more,
And
John.
one more bill, and that's again from the bankruptcy attorney. It's 51669, and it's again $88. I make a motion for it to be paid.
I
Second.
second.
Chris seconds. Barring no discussion, all those in favor? Unanimous. Okey doke. The next item on the agenda is committee reports. Randy, on the legal committee?
Yes, it was already mentioned, but I'll just repeat it. In the Burnham case, the agreement, the settlement is reached. We have already received the title to Unit 108, which was part of this settlement. We are still waiting on the check from the various insurance companies. We are going to receive a check for $100,000. We have not received that yet. As soon as we do, that case will then be dismissed. It'll be over.
Randy,
Questions on that one? Yeah.
Randy?
Yeah.
Are we getting multiple checks from multiple insurance companies?
I don't believe so. I think it'll be one check. Not positive, but I think it would be one.
I think that's correct.
Yeah, it'll be a check from her insurance company. Is that correct? Because
Yeah,
yeah,
her insurance company put up $500,000. That was
Yeah.
that was the policy.
got it.
Correct.
That makes sense. That makes sense.
Yeah, there were other insurance companies involved in the suit, but there's only one company that's responsible for the payout.
Absolutely. Makes sense. Sorry I didn't figure it out on my own. Appreciate it.
Okay, in the Seward case, we've been made an involuntary plaintiff. There was a countersuit there. We didn't officially join it, but since it benefits us, we are an involuntary plaintiff. The hearing was last week. There was a question about the defendant in the countersuit. There was a question about the defendant's right to counsel, and so the judge, in light of that, the judge has continued the case until October 19th at 1:30. So that's where that stands. Questions on that one? Okay. And then in the Porter lawsuit against the board, or against the association, our lawyers in the Reminger firm, who are paying that as part of our handling that case as part of our D&O coverage, they have received our draft responses to the interrogatories that the Porter faction sent to us. They have the draft responses. They will work with those, consult with those. They will get those back then to us if there's any, if they have any questions or legal advice, and how to rephrase or do whatever it is with this. At any rate, that's where it stands. They've got that. And so we are waiting on our lawyers to contact us as to what the next move is there. Those answers will eventually go back to Lundergan, the attorney for Porter. And yeah, we are also, our lawyers talked about that they are also going to create some interrogatories not in response, but back to the Porter plaintiffs as well. And that, I believe it's still set for a March court date.
Randy, do you have any idea when all these interrogatories have to get back to the plaintiff, what the deadline is?
Originally, we got them in June, and they were originally due at the end of, I think they were due in like 2 weeks, which was mid-June. We got an extension to the end of June. Tracy, help me out. When did you get your answers in?
So mine was due July 15th, and then I submitted them before I went out on leave. So he did do the extension. Randy, to your point, it was a very long list and took a lot of time to upload. So it took me a couple days to actually do it. But he said the drop dead date was July 30th, 31st. And so I was able to finish it by then.
Part of the issue there as well is that we merited these extensions. It was a suit against the board. Well, we now have 7 board members who aren't except for 2, aren't the same board members that were on the previous board when the suit was filed. So it was a little confusing as to who do you want these answers from? So that took us a while to figure out. And then we unified on that. We did create, one set of answers that we feel is accurate. And so I guess mid-July was when we finally got it to Reminger.
They still have not been finalized yet. They're very close to finalization, but I don't think they've been submitted to the court yet.
In that regard, can we get some kind of timeline from Reminger?
Sure, we can get the date, although they change them all the time.
Got to start somewhere.
timeline slides around because
It was a lot to go through. It was a lot.
because it depends on how fast Lundgren's people get through it and all that other stuff. So we can
Yeah.
ask them. I don't think it's a very firm timeline.
But to your point, it sounds like we're still sending interrogatories back to
We're done. We're
We're
waiting
done.
on Remington. And then they're
Reminger
gonna-
still sending them some? Is that what I heard is being
Yeah.
discussed?
It's the ball is in the Reminger's court right now.
Yeah.
They have the interrogatories. You know,
And I'm sure that the court has some process that says once the plaintiff gets those, they have X number of days to respond. Can that get moved? Absolutely. But it'd be nice to know what we're dealing with because we're marching towards March.
We'll keep you informed.
Randy, I'm sorry, I want to jump back on Seward. Now that case was for the dismissal of that suit. Wasn't that what that date was all about?
yeah. Uh-huh.
So the dismissal, the decision on the dismissal now is pushed out until October.
Correct.
Okay. Next thing, any other discussion by anybody on legal issues? Okay. Next item on the agenda was Finance Committee, and Tracy said that she will get back with us after the Finance Committee meeting on Monday.
Tim,
Yes.
in the last two meetings, we asked the Finance Committee to meet and be here with an answer on the HOA assessment. For whatever reason, it wasn't done. I don't understand that, but it wasn't done. That's an issue. The whole point of that was to be able to review, and if we were going to make a change to the HOA assessment, we could do it in time for September. I'm ready to make a motion to do that.
John asked me as a part-time participant on the Finance Committee to chair the Finance Committee, and I told him I was uncomfortable doing that without Tracy being there because she and I have divergent opinions on a lot of things. So that's why it didn't happen. Tracy was unavailable, and I was not comfortable running the Finance Committee meeting.
And just for everyone on the call, I was unavailable because I was in surgery, and I made the board aware of that and that I was not going to be able to participate until then. And Gil, I did receive your message before I left, and when I came back, that you had questions about that. I did say we're going to meet about it in the Finance Committee meeting, which is what we're meeting about. The timing to say that it should have been done for September, credits and debits can happen all the time. The timing doesn't mean we can't go back and make changes or adjustments to billing and things like that. So it'd be best if we look at the current state of the financial situation, which is what the Finance Committee is going to do. And then we're going to make that assessment, like we said, I've said in email 3 times, and bring it back to the board. Based upon that, we will have to vote if we want to make changes. And if we say, hey, we should retroactive something, then we can do that. There's called accounting where you can do the debits and credits to do that. So this is not something that needed to occur while I was out having surgery.
We asked for it to be done before the next meeting. Has nothing to do with you being out on surgery. This is not a job. When somebody is missing, somebody else should be stepping in and taking that position. You are not running the entire treasury and the reports. We have someone who does that for us. So for somebody, we got 3 other members that could have just stepped in. We could have had another chairperson to bring a 4th person into that and accomplish the task. So that is not an excuse.
I'm not making an excuse. No one agreed that this would happen before I went out.
We have owners who are suffering, and we should not be charging them for more. This is
No
not
one's charging them for
whole thing
more.
about debits and credits is not the situation.
No one's charging them for more,
Situation
Gil.
is that we're overcharging based on
No,
what
we're
our
not.
document
No, we're
we
not.
are. Stop talking over me.
No, we're not.
are not abiding by the governing documents, which says that we're supposed to charge against our expenses.
Mm-hmm.
So my whole
Mm-hmm.
issue was we threw that $84,000 in there that we
Mm-hmm.
didn't need to put in there. We decided we were going to
Mm-hmm.
move the insurance out. Our budget is set. We need to balance that, what we're charging our owners in an assessment based on what that is. And on top of that, that $84,000 needs to come out. That's going to be around a 7% reduction for all of our owners. And I just to give this back to our owners.
So per the documents, it does balance, and we're going to agree just to disagree. It does balance. The fee does balance with the expenses. Now, what happened was we voted as a board, just so everyone is aware, we voted as a board, we voted in the board meeting that we were not going to change the HOA fees. We talked about in the finance committee, we talked about in the board meeting, the budget meeting, all these meetings. So then to come back and say that you want something done before people go out on leave or who's not available. It takes time to do that. And it takes time to do it with the people who are involved with the financials. I said it will be done. We have a meeting on Monday. We will come back to the board.
We did not. We are not charging our HOA assessments
John has his hand up.
with budget.
John Morowitz.
Yeah, I'd like to just move the agenda. I think we understand everybody's point of view. I don't think we're going to resolve it right now. The finance committee is settled to meet Monday and they should report their findings back to us.
John Webb.
Yeah, I think there's a translation issue with the way the bylaws are written. And Randy called this out in the last meeting, Tracy. You charge per the bylaws the percentage of ownership based on the income, not the late fees and all that. That's one thing that wasn't done right. You can't just say, according to the bylaws, that you charge it that and keep it the same unless the income is there. And I think that's a misunderstanding. I think the other thing is there's an error, whether it's 84,000, it's a typo when you balanced it, and I saw where it happened, then we need fix. And so those are the two things. So I think there's a misunderstanding on how they're calculated. And last year, to be fair, there were a lot of complexities. Greg, our dues had been prorated, so they were more, not 12 months last year because they were more for the thing. That it was like $5, not a big deal. And then the other thing was you all decided that we were going to make the income fit with the budget because you didn't like where we were standing and we were afraid. And it was a unique year. This year's different because we know about where the expenses. Tim did a great job of trying to estimate. You did as well, Tracy, in trying to estimate. So I think we just have to go back and look at that and make sure that we're following the governing documents on how they're assessed, whatever that income is. That's all.
All right,
Let's
Next.
move on.
next items, updates and announcements. Next thing on the agenda is appraisal matters, and that would be Gil.
So it turns out that upon further review of the appraisal, there were some differing information, whether or not the undeveloped property was included in the appraisal or not. It's my understanding, and John, you can jump in here if necessary, but Colliers came back and revised the appraisal, the second one they just did, to clearly state that it is for the property that the building sits upon and the pool and the parking lots, and not the undeveloped property. As it turns out, the buyer is also asked Collier to do an appraisal on the undeveloped property. And from that, we would expect to see some additional value in the total property. So we'll keep you updated as that comes in. I would expect to see that in the next week, if not two. Tim?
Yeah, just to clarify what you said, Gil, I think
Sure.
in the original appraisal, in the appraisal from Colliers, it's stated the Hammond North sits on 18.97 acres. And that's not true. 18.97 acres is the undeveloped property. The Hammond complex actually sits on 10.76 acres. So what Colliers is doing, and we haven't really resolved how it's going to work out yet, is that now they're stating that Hammond North sits on 28 point whatever acres, the 18.97 plus the 10.76. So so that's where we are right now, is they're trying to figure out how we're going to capture the fact that the original appraisal said 18.97 acres. John.
Yeah, it's exactly what Tim said. Both the original appraisal done in December 2024 and the revised one that we just paid for took it up to 17.1. Both appraisals had the undeveloped 18 acres on it. That was pointed out. I think Gil said that was one of the questions. Mike Stacy was looking at that. And so they revised that, and we had a revised appraisal, no cost to us. We point out the problem, and they gave us appraisal at the same amount, $17.1 million, but only the 10 acres that the building sits on, that those 10 acres are owned in the deeds, the titles for each one of our units. We own the unit and the common areas, and if you look at yours on the county website, it shows you the property of the 10 acres. So it sounds a petition, which I think most of us thought was an error, was filed only on the units that they can't divide the 180 units and the 10 acres it sits on. But the petition does not include the wooded areas, the undeveloped areas. And from what we went back and forth with Julie on it, she said that's the way it is because the HOA owns the undeveloped area, unlike the 10 acres that are owned by all 180 owners. I find it dumbfounding, and if you look at the declaration, the number of points where it says we sit on 28.9 acres, it says it's property line to property line. But what Julia said, and we can pursue this further, is a petition can only be for property that is the title is in common with a number of owners, which is the 10 acres. So what we're stuck with is probably, direct sale goes through. The PSA clearly involves everything. No problem there. If we go to partition is only going to be for selling the building and the 10 acres unless something changes, and we can sell the 18 acres separately.
Randy.
Yeah, if you want to understand how this could happen, maybe some of you who have lived in the building for 40 years know this, but as I understand it now, when the condo association was set up, we only owned the 10 acres that are developed, where the building sits, the parking lot, the swimming pool. That was it. The other parcel, it's a separate parcel listed in the county, includes the meadow and the woods and the stuff south. So we have a north parcel and a southern parcel. When the condo set up, we only owned the condo association only owned the northern parcel. A year or two after the condo was set up, I believe it was in 1985, the south parcel was purchased by the association. So Julie's argument is that since 180 of us own the original parcel of 10 acres plus our own units, that can be partitioned, because a partition works when a whole bunch of people own one piece of property. But the problem is only the association as a corporation owns the southern parcel. So it can't be partitioned, according to Julie. I'd almost like to get another opinion here, because this is going to create a stink for us. As John said, if we go to a sale, if Mike can buy the building, he's buying both parcels, we're cool. But if not, if we have to go to a partition is only covering the north 10 acres that the building sits on. And so we are going to have to put the other 19 acres up for sale on our own. I don't know. So, that's just going to be one more hassle to deal with if we go that far.
Gil,
My only comment is that we're still going to have discussions with Finney about that position that they're taking, because from what I'm reading, that's not, we've got an opportunity to do something there. We need to address that and go after that.
I agree.
I agree. That's why I was a little bit less definitive and just said that we're still in negotiations on how to handle it.
Yeah.
Can we unmute Carolyn?
To click.
Hello,
Okay, it's your turn.
can you hear me?
Oh,
We hear
thank
you.
Let me say that a good lawyer will figure out a way to bring this thing together. My guess is over the years, the properties that we own in our own names are the properties that paid to mow the grass and do other things in this so-called extra 10 acres. To go proceed with just the 18 acres is utter stupidity, because then you're going to be left with 10 acres to start all over again with another partition action with all the same plaintiffs, basically the same land, and we'll slow this thing down by another couple of years, which will cost each of these owners, myself included, a ton of money for no purpose other than to enhance the pockets of the lawyers. And I'm speaking as a lawyer, but unfortunately, my pockets are being stripped there.
Jim, I understand your point, but I just want to make a clarification. It's actually the opposite way. The 10 acres is part of the partition. The 18 acres is not part of the partition.
Well, then go forward with it.
That's what
Do
we're.
whatever's necessary to go forward with it, or close the deal with Mike. One or the other. I don't see any purpose-driven activity here to see that goes through. I've heard nothing tonight about where we are on that.
We have not gotten to Gil's report yet on the PSA.
Okay, thank you.
John Webb.
Per the history that's on the Hammond, we didn't buy that. It was not. I got muted. Okay, if you read the history that's on the Hammond North website, it states there that it was acquired through a settlement because it was not disclosed that that was not part of the property when it was sold as condos, amongst other things besides building need repairing and things of that nature. I don't know if that comes into the conversation, but it wasn't purchased. And I'm just reading from the history that's on the website and what was written by people long before me. So that might be worth looking into and trying to find that lawsuit and see what it actually says. So just a suggestion there. Thank you.
It was our understanding from some people who seem to know what they were talking about is that you're right. Hammond North threatened to sue the real estate company for not disclosing that that property wasn't part of the deal. And again, it was our understanding, I don't know if it's historically accurate or not, that there was a settlement where Hammond North paid some money to transact that, but we'll go back and see if we can verify that.
Here's what the history says. A third previous undisclosed fact was that 18.9 acres south of the building had not been included in the sale. After 2 years of litigation, a settlement was reached and that returned the land and included monetary compensation. Again, I wasn't there. I'm just reading from the history, so hope it helps.
Understand. Randy?
Yeah, but I think whether bought or in a settlement, the bottom line is it was deeded to the association after, the declaration and all that kind of thing was made. And so apparently, it's two separate parcels. It's taxed separately. I believe we, we owners on the north parcel, we paid our own property. That's part of our individual property taxes that we each pay. The southern parcel is paid out of the association treasury, the taxes. So I think that's the problem, is you can't, according to Julie, you can't partition something that only one entity owns. It has to be a common property, which is the north parcel. I agree with Jim Sissel, is we've got to find a way to solve this, or we got to get Mike through on the sale of the building.
All right.
Chris,
I'm just gonna, the original declaration, which was written by a Chicago law firm who was representing the owners in the sale of the building, listed the property as 29.87 acres. They only got 10. So that was the basis for the lawsuit. The original declaration listed all the property. So I'm done.
Now that might be a good arguing point for us then anyway.
All right. Needless to say, a lot of work to do there.
let me throw one last thing in here, if I could. One thing we got to be very careful of in that whole program is if we sell the 10, we don't have an easement to get to the 18.7, we'll have a heck of a time trying to sell something that a buyer won't have the capability to access.
I looked on the plat, and it looks like there is an easement. Now, how that's going to happen, with the hearing.
I think that's a utility easement.
Oh, is that what it is?
I think so.
All right, we'll have to get into it. I've got some questions about it with the auditor's report also, so we'll have to check that out. Next item on the agenda is the disbursement update. Jan or Chris?
Well, Tracy, you wrote the minutes from our meeting. You wanna go ahead with this, or?
Sure. I can do that. Can you hear me okay?
Yep.
Okay. So the update is today, the distribution working team met with Rob at Prominent Title, and we discussed the high level process, what we're paying for, and then what the next steps are. So the preliminary high level process will be that mid-September, owners will start receiving emails from Prominent asking owners to sign their settlement statement. That settlement statement is how much an owner will get for their unit, what needs to be deducted, such as mortgages, taxes, HOA back fees, and then how much will be sent to you. The board will send out a one call when an engagement will start, and we'll also let you know who to expect the email from. Owners can e-sign that form, fax, call, or take it to Prominent. There will be instructions included in the email. Owners with mortgages will also receive an authorization form to fill out, and that authorization form supplies the account numbers so that the funds can be wired to the bank for that mortgage. Also, if units are owned by a trust or LLC, those owners will be asked to provide the trust documents and or the LLC operating license as a part of that package. Just note that owners will not receive funds if these items aren't completed and sent back. Owners will have the option to get payouts wired at no charge to their bank account, or a check will be overnighted. We believe they're going to use FedEx. Owners should start receiving payments mid to late September. The working team has already shared the August delinquency report with Rob and the updated contact information. If you have not had a chance to update your contact information, please share that with Jan. We want to make sure it's the most recent that we have. Next, we're going to be working to get the distribution funds over to Prominent. So Tim, I believe you sent an email earlier. We will pull in Greg as well to talk through that process to distribute the $11 million and the $61,000 for the payment. We will also meet with Rob again on September 4th to get a status update and share that with everyone in the board meeting. Prominent will also provide the board weekly reports to tell us where they are in the process. It would also tell us what checks were mailed to whom, what the status is, if they couldn't reach someone, or if we received something where we need to actually help the owners get through the process. Originally, we were quoted approximately $30,000 for the distribution process. And I believe while I was out, it was approved to move forward with the $61,000. But I just wanted to share some of those items and cost explanations in this board meeting. So the things that the Prominent will do, obviously they will do the title searches, which are already underway. What they verify is they verify if any liens are on the property. They check to ensure that what's on the title actually matches the owner's information we provided. They'll reach out to the mortgage companies to get payoffs, which they're in the midst of doing as well. They ingest the HOA delinquency report, as I mentioned before, to be a part of that distribution process. They're creating accounts for HOA for us to wire the funds to distribute. They're creating settlement statements. So the settlement statements that I talked about before, they're actually creating those for every single owner. They have also set up the e-process to sign those settlement statements. They provide wire funds to transfer. So if an owner decides we want to get the check through a wire or we want to receive it overnight, they will do so as well. And they provide the status updates. Rob also did mention that he will personally provide his cell phone number or office number or even his team's number, just in case the owners want to talk through the process, if they have any questions or if they need assistance with anything. So those are the things that comes at a cost. I know we talked about that cost before. And the good thing about using Prominent Title is that because we're also using them for the direct sale, a lot of the processes that I've just explained will reduce any rework that another title agency would have to do. And we will also improve the process for the sale distribution. I know that was a lot. We'll make sure we definitely post the process on the website.
Yeah, I will put that up tomorrow if I get a second.
Okay.
Dan?
So I want to thank everybody, all the floor representatives and all of the owners who submitted their information. That was really a phenomenal effort and it's all submitted and we're good. I also, a couple of questions have come up. If people need to respond to this, and I think people are responding, so that's not a concern. If somebody doesn't respond, it will slow down your own individual payment and resolution, but it won't slow anyone else's down. So please rest assured that that's the case.
Randy?
Yeah, question, Tracy. On the checks that are going to the mortgagees, to the mortgage companies, do those go straight to the mortgage company or do they go to the owner who then sends it to the mortgage company?
The way Rob explained it is it will be a wire. And or if they say they do want to check, it will be addressed to both. But I believe it will be sent to the mortgage company.
Okay.
You'll get signed permission, I think, to that on the
authorization form.
Yeah.
Mm-hmm.
Bill?
So, can the committee find out what the drop dead date would be for the distribution to be able to match up with the sale of the building? Not sure I'm being clear on that.
Yeah,
If
you
we
are.
close,
Yeah.
go ahead. If we close in 30 days, I don't think we want to distribute within that same 30 days, a separate situation. So I'd like to find out from Prominent, at what point would they need to know that we're going to closing in order to match that up and reduce our cost?
So what we were talking about today is this process will literally get started in 2 weeks. So phone calls and emails will start within 2 weeks. Because we're using Prominent, they would rest assured know when that timing would be. I don't know that we're going to close in 2 weeks or by the end of September. So is that what you mean?
That's what I mean.
Oh, Chris, sorry, go ahead.
Yeah. Yeah. Prominent is going to be handling Mike Stacy's closing, and all of the work that is being done with the distribution of money will also be done with the closing. So if nothing else, this will be preparation work, and it'll make any closing go a lot easier.
True,
Because
but
he'll have all the information that he needs.
Mm-hmm.
well, having said that, if we close, say, middle of September on the distribution, and we close at the end of September or the 1st of October with the sale, they're going to have to go back and do a refresh for those 2 weeks to get it done.
Well, they are, because a sale closing title search is a 40-year title search. And the title refresh we're doing is not a 40-year refresh. So that's work that Mike Stacy will pay for regardless.
So basically what you're saying is anything for the sale, Mike's paying for, so we shouldn't be concerned with that.
That's actually, we're helping them. But we're not
that's
paying
gonna
a
happen
lot.
either way. So there's no benefit to the HOA to do both distributions and combine the two distributions into one distribution.
There's not that I can see.
Tracy, do you have something to add? I'll call on you.
Yeah, I'm trying to follow the question. Gil, are you saying that we're going to be closing on the direct sale by the end of September? Is that?
That's what I just said. We could be closing in 30 days. That's what the buyer told me.
Okay, unless I'm missing some. Okay. Yeah, we could talk about that during your PSA update.
Mike has indicated that he wants to go fast. So it's just, Gil is just throwing out the possibility that
That's exactly right.
But we just did an extension. So
Yeah.
help me understand that logic.
But the extension doesn't mean that he needs to use all 60 days. He just didn't want to come back multiple times on an extension. So he has an extension on the due diligence for 60 days. But that doesn't mean he needs to use all that. You know, if he gets the stuff from Mark Dahlberg, if he gets his financing stuff, that could all happen in the next 2 or 3 weeks. I am not quite as optimistic maybe as Gil is, but Gil has spent more time with Mike than any of us have, and Mike in the dealings with Gil and in the part-time dealings that I've had with Mike has indicated that he wants to go fast. John Marwitz.
Yeah, I understand that Mike is optimistic, and there's one end of it is whether he needs those 60 days for due diligence, but and the financing and the permits, there's also our end of it. As a direct sale, we need agreement with the mortgage company, so we need agreement from 178 owners that they're going to sign quitclaim deeds. And I think that will take some time. And I just think that, although I think theoretically what Gil raises is possible, given what Chris said, that it's the same title company, that helps us. But I don't think it's realistic that we have to worry about that, or that in any way we should hold up the distribution of $11 million to the owners, because what theoretically may happen and what work we have to do to get 178 quitclaim deeds. I'm not optimistic we can do that in 30 days.
So I think, you're staying on top of the PSA. We're staying on top of the distribution. We will be communicating weekly, certainly. And as the situation changes, we can pivot for another week or so, or two, maybe. If it looks like it's imminent, please let us know.
Yeah, Gil, based on what Rob told us at the meeting this morning, the process is going to start right around September the 15th. That's his plan. His plan on September the 15th, he's going to start issuing emails with settlement statements on them. And just so everybody is aware, I don't want anybody to be surprised. This isn't going to happen in a day or two. There is going to be a process, and some people's settlements and checks are going to be easy, and some people's settlements and checks are going to be more difficult. So the payoff is going to stretch over some period of time. We have stressed to Rob that we don't want that period of time to be very long. So he's sort of thrown out the fact that it will start in the middle of September, and hopefully he'll have it done by the end of September. Now, there will be probably a couple very complicated transactions that might have to stretch into October, but that's not going to hold up the majority of people. The majority of the distributions, based on what he told us this morning, are going to happen in the second half of September. Jan, Tracy, did I misstate anything?
No,
You're good.
Absolutely right.
Okay, Gil?
So I hear two things there. One, September 15th is probably that drop dead date. We would have to know if we're in the fast track moving to closing, and to John's point, that we can pull it off. And the second thing that I hear, though, is Chris saying that it doesn't make any difference about the sale part because we're not paying for it anyway. So if that's true, then it's a moot point. And I back down.
Mr. Smiley, can we unmute Mr. Smiley? You're unmuted, Dave.
Who's muted?
He's still muted.
Yes,
there you go.
can you guys hear me now?
Yes.
Yeah, I have a quick question. It's regarding the sale. Does Mike Stacy have available funds of $12 million to buy the building?
I will get to that in a few minutes.
Gil will talk about that in the PSA.
Okay. Look forward to it.
Okay. No further questions on disbursement. We will go to PSA update. Gil.
So the first thing that I was going to talk about is we did have an extension of the due diligence period. We did a unanimous motion via email on the 20th to accomplish that. It was a motion made by me and seconded by Randy and unanimously approved by all the board members. That motion was to move that the board approve an additional 60 days of due diligence period for the purchase sale with Hammond House LLC. So that's the update on that. As far as there was a bunch of questions that came my way about this. There's questions about the lightning strike damage, and is that something we've said we'll pay for? The question here is, he doesn't know, we don't know, we, the HOA, don't know how extensive that is. That is why we brought in the lightning protection company to see what they find and what needs to be, if anything, put in place to prevent future events, lightning events, from impacting the building. So that's just part of due diligence. The same thing, there was a question about IBI and the cost of electric repairs and replacements and all of that goes into it. Again, part of due diligence. When you say it was he got into this contract as is. There's a mistaken belief that as is means that they're going to buy it regardless. What it says is they get to do their due diligence and come back and say, after looking at all of this, we can't take it as is because there's too many other issues out here. That's what the due diligence is about. You get a full understanding of the costs to develop the property. If the costs are too high, the buyer is just going to walk away from it, or they're going to come back and try to renegotiate. I'm not saying Mike's going to try to renegotiate here. That's what happens in a buyer-seller relationship. If the buyer gets into it after doing due diligence and determines that there's issues here that were far greater than they thought, we can't buy it as is. So, and they walk. So I think that answers most of those questions. As far as the money, Mike's been working with several different people. He has commitments from different people, which he's going to share with us. I expect within the next week when he solidifies who that's going to be. He tells me that he's getting much more interest, and people are actually coming to him trying to get involved in this purchase, where before he was out trying to find the money. Part of this process is this whole undeveloped property, which is going to add additional value to not only the developer's side, but for what the value of our property is as it sits. So that's where that stands. And then as far as the permits go, he has been talking to Art Dahlberg. He got some good information, some good feedback from Art today. He told me that seems to indicate that the permits are going to be within the time frame of what am I trying to say? The coverage, the rules, the permit rules, as of when they were originally provided for the hunt builders. All that's still yet to be vetted out. He's working with them. I think he has another meeting with them tomorrow. Any questions?
Randy?
Yeah, the extension of the due diligence period was extended for 60 days. But that's not stretching out the PSA longer than it first was possible to do. The PSA had a built-in provision for Mike to be able to request 90 days extension on the entitlement period, which is the stuff where he's getting the permits and things like that. And so he had already said that he wanted to extend the entitlement period. So now we've extended the due diligence period where he's allowed to, explore issues in the building. And that's going to run concurrently with this 90-day extended entitlement period. So it's not like we've pushed this sale any farther along than it already, any farther into the future than it already was.
Thanks, Randy.
John?
Yeah,
Morris.
I'm just wondering, Gil, what is the latest development about the communication I've had with Mike about the HVAC repairs?
He did mention to me today that in further conversation with the vendor, that is going to probably be half of what he reported in that email to all of us yesterday.
Thank you.
He appears to have gotten a reduction in the estimate, so.
And again, that's all part of that due diligence of sorting things out and getting a good hard number on these things. He wasn't asking for us to pay for it. He was just letting us know that there were additional costs that he hadn't planned on. The number he's got now is consistent with the number he had in his projections. So he's much more comfortable with that, is what he's told me. Tracy.
So the projections that he has during his due diligence, and I know we extended it to give some more time. Does that include the 5-ish million or so dollars for the work that needs to happen with IBI? I believe that's what it was quoted back when we were in this deal with ACM and they bowed out.
The electrical costs are still in discussion.
Okay. So
And-
he has not come back and said, that he requires any adjustments to the actual contract or purchase price because of the project cost he's now estimating.
He has not.
He's made us aware that he was a little uncomfortable, but like Gil said, he's also now coming back and saying that some of the other costs are coming in the line. So his overall projected expense is more in line with his original projected expense.
So considering all the things we just talked about, like due diligence and projections and working with Art and him wanting to move faster and getting through the financials, what do we think and I know he has 60 days to close, but what do we think that closing period will look like? I know he wants to move faster than what's in the PSA, but what are our thoughts about like next steps and how we move forward?
What you said is what the answer is. We don't, we know what we know. He wants to move fast. All depends on what the city building department does and some of these other numbers that we got to find out what's going on with the lightning protection situation.
Really, Tracy, I think the only thing we can say, it'll be 60 days or less.
I know if those get cleared up, he's going to want to run fast.
Okay, Mr. Smiley?
Yes, can you guys hear me?
Yes.
Okay, help me understand, Gil. My understanding at this point of the ball game, he hasn't secured finances yet. Is that correct?
I would say, as far as that's accurate, yes.
And you want to move fast and you haven't secured finances. That doesn't make sense to me.
But because he's saying he's going to move fast once all of that is secured, not just the financing, but also the permits.
And I guess my question too is why aren't the finances already secured? It seemed like they should have been secured.
I explained that. It's all part of the due diligence. The investors want the due diligence completed before they will sign off on the loans. Part of that is they're actually going to go out and get a second appraisal on their own that they've controlled, so they know what they're getting.
And they also want to, I believe, correct me if I'm wrong, Gil, they also want a projected estimate on the overall cost of the project, which that's sort of what we're working through in due diligence right now, is so that Mike can put a good number on that. They want to know what it's going to, they not only want to know what it's going to cost to buy the building, but they want to know what it's going to cost to fix up the building and how is that all arranged. So, and he's negotiating. The other thing is he's negotiating, as far as I know, with 2 or 3 people that we're aware of. And when he gets those final numbers, then he'll make a deal with one of those guys. John Morowitz?
Yeah, Gil, did I hear that right? That he can't get a letter to us of securing the funding until after the due diligence, which could be maybe just 10 days, 20 days, but that means it could be 45 or 60 days before we get the letter of financing.
Before it's a hard number, probably correct. I mean, when we got the original letters that he was going to be able to get financing way back when this all started, it all said based on due diligence.
Oh, I did not know that.
We'd have to go back and look at that letter,
Right.
That wasn't,
What difference does it make, really? Because what are we going to do? We're going to walk
well,
away because he hasn't turned in.
no,
He's
no,
on that, and he's going to get us the information. It makes sense that they're going to give it when they have the due diligence done, that they know what they're buying into.
I understand that, but that wasn't part of the discussion last week, the unanimous consent motion. And Mike wants us to move fast, which I think we should. But until we get the permits, and as other board members have mentioned, both the permits and secure funding, it's going to be difficult for the board to get 178 quitclaim deeds. So if we don't have the commitment that we see this funding, I think we're going to have trouble. And I don't know whether we can go to all the owners to get their quitclaim deeds until we have the proof of funding.
I would suspect that we wouldn't even ask to go get those quitclaim deeds until we have the funding. So once that's
Agreed.
done, and that has to be done by due diligence, then there's 60 days to close. And those 60 days of due diligence are 30 days short of entitlement. So it should not be a problem.
All right. I think the other two bullet items there, we've already discussed. The Mike took advantage of the 90-day extension on the entitlement period, and we gave him a 60-day extension on the due diligence. And just so everybody understands, last week I know we put out an emergency notice that we were going to have an emergency meeting on Friday. We ended up canceling that meeting as a result of we did a unanimous consent on Thursday evening and got that to Mike on Thursday evening. So that was why there might have been some confusion on why we scheduled an emergency meeting and then canceled it. We wanted to get together and have a discussion, but we did the discussion offline, and we did it through a unanimous consent motion. Mary Merriman, can we unmute her?
I think to sum this up, I want to be clear, whether or not the total sale goes through with Mike in 60 days or whatever, depending on these factors, that is not going to affect the disbursement in September of the landmark funds. Am I correct?
Yes, you are correct.
Okay, so if we get our disbursement of landmark, that buys some of us poor people some time to wait until maybe another 60 days till the total sale of the building's money gets dispersed. Correct?
Yes.
And then I was also advised that with taxes, it may be better to do it that way because the disbursement of money from the insurance may not be taxable, where the disbursement of money from the sale of the building could be capital gain. So it would be better maybe to have those two separate checks.
What you have to, I just want to make sure that you're trying to get an overall understanding. We gave him 60 days extension on due diligence.
Right.
He has 90 days extension on the entitlement period. And then after that, there's a 60-day closing period after that. So we could be as much as 150 days.
Okay. But in the meantime, in September, we should get our disbursement of landmark funds.
Yes.
Okay. That you see, that disbursement of the funds makes this possible extension more palatable. That's what I'm saying.
Thank you.
Okay. Thank you.
All right. Given no more discussion on the PSA, John, you had an item here on missing and stolen property.
Yeah, an owner reported to us that she was missing some furniture after she left the building with her possessions, and that those possessions were then missing. And when she went back at some point after she was well out of the building, we discussed it among some of the board members and agreed that that wasn't something that we would cover, that would be covered by someone's personal insurance. It's unfortunate. We shouldn't have happened, but that was what we had said. I don't have a motion per se. It's more information purposes and discussion. I don't know if we need much discussion on it, but you want to discuss by the board.
Mary Merriman again.
Mary, did you want to put your hand up?
Oh, Mary, do it again. I just unmuted you. I'm sorry. There you
Okay,
go.
can you hear me now? I went over and dropped my HOA money and I was asking about the packages still there. And Mickey told me, you know, because they can't just come in anymore and drop packages, that apparently I guess FedEx and Amazon and whatever, they're delivering them to the dock. Oh, instead of where they used to go to the lobby, they're delivering them to the dock. So is it possible to alert or put a one call out to owners that if you order from Amazon, make sure you've changed your address, like corrected it, don't mail it to the Hammond anymore, or in any other things that you have that would be coming, that your address is current and that does not include the Hammond address? That some of the things that had been delivered, you know, were delivered to the Hammond by owners, but they don't live there anymore.
I think that's a good idea. Randy, you and I can draft a one call about that.
Okay, thank you.
Any other discussion? I don't know, just to go back to what I raised about missing possessions from a balcony or a unit.
All right.
Tim, I think we can move along.
Next item is surge protectors by Gill, and this was brought on as a result of the lightning strikes that we've endured the last few months.
Before I go into that, I would like to ask about that crime policy. Where do we stand on that? I think, John, you were handling that.
You and I should talk about that. I thought you were looking into it, and I thought it was basically another insurance policy with
It is.
Treehouse.
It is.
Let's talk about it tomorrow morning.
And then we have to wait till the end of September to. Okay.
No, let's try to resolve this tomorrow morning.
But we have to bring it to the board to agree to pay for it.
We don't have a motion for a bill for an invoice, so there's no way we can approve it now, as far as I know, except I think we already talked about it and said we'd
Because you've been sitting on it. All right. Surge protectors. We asked Greg to go in and identify if we could get additional surge protectors on the fire alarm system that we just paid to have repaired. They did put a surge protector directly on the fire alarm system. We asked if they could put additional suppressors within the system to further protect it. They came back with a price of $1,143.60 to do 3 more suppressors. I would have said, let's make a motion and do this. My thought is, let's hold on to that. Let's see what Maxwell, the lightning protection people, come back with, and see if after we get their report and that system is whatever has to be done to that system to make it effective, if it's not effective now. Perhaps we don't need to spend that $1,100, and perhaps the new buyer will want to spend that $1,100 rather than us. So I leave it up to the board to have a discussion, but I'm leaning into, let's wait. Since Maxwell was there today, I'm assuming we'll have something back in a week, and we can make a decision based off of that. Thoughts?
Sounds good to me.
I agree.
Yeah.
It's my surge report.
Tracy,
I just had a quick question too. I think Greg is still on. Is he still?
Yeah, he's there.
Okay. Greg, I was wondering if you can do something. So during this board meeting, we've talked a lot about costs, building costs that are coming up. I know some we've paid, like we just paid a $9,800 bill for some work we had done. We talked about the coolers. We talked about other things today. Can you make a list, or we can start creating and add to a list of all of the unexpected expenses that are coming up that we haven't seen just yet? I think that'll be helpful to share with everyone.
He's
needs-
muted.
Oh,
Oh. Sorry, Greg.
there we go.
Absolutely. Barring any additional initiatives, as of right now, we have experienced any expenses to date, barring any other unforeseen or any other surprises. So I will send you that. I had distributed some of that previously, but I'll put it together and send it to you in a pack.
Okay, thank you. It'll just be helpful when we have
Sure.
the finance conversation, because there's a lot of unforeseen things are happening.
So in addition,
you.
Greg, you've got whatever the lightning protection cost is going to be. We still have the camera costs to put in there.
That's true.
And
Yes.
and that elevator, that was just for the circuit boards. Was that for the installation as well? That 3,300?
I'd have to revisit that. I don't.
That's fine.
I'm not,
That's fine.
I'm not familiar with the 3,300, so I'll have to revisit that.
3,300 was the repair cost for the board.
Yeah, the elevator repair.
That was the repair cost. that you
Yeah,
quoted
that
for the board.
Yeah, that's what I was asking. Was that just for the boards to be refurbished, or is that the total refurbishing plus installing them?
I don't have that final number yet, so let me revisit that. If I don't want to misspeak on that.
That's fine.
Okay. Given that everybody seems like they're talked out, do we have a motion to adjourn?
So moved.
Second.
Motion to adjourn, there's a second. All those in favor to adjourn to executive session? So moved.
Everybody.